district. But it also would allow as a conditional use the development of electric power generation on the parcel. The third option is to create what we call a power plant overlay district. And that would allow electric power generation facilities in a portion of the M1A zone. And that portion is all on what I'll call the uphill side of the Casey Highway. That's the M1 land on the uphill side of the Casey Highway, designated as a power plant overlay district to the M1A zone. The M1A land that is on the downhill side of the Casey Highway and in closer proximity to residential districts would not be included in that zone as proposed. The fourth option to correct the defect would be to amend the M1A district to allow power generation uses throughout that district. And that is incidentally the recommendation made by Lackawanna County Regional Planning Commission. But as I said, we've proposed 4 alternatives. Any of those alternatives would effectively cure the defect that we've identified. With respect to each of these 4 options, the project would be classified as a conditional use, and therefore subject to all of the requirements and standards for any conditional use in the borough. There would need to be a conditional use proceeding to authorize the specific project, including extensive environmental assessments as required by your ordinance, and other standard terms and conditions that apply to all conditional uses. Each of these options also would effectively amend the ordinance with respect to height limitations and building enclosures, so that those current limitations are no longer applicable to certain electric power generation facilities, which necessarily must be taller than 70 feet and are not customarily enclosed within a building. That's a summary of the curative amendment proposals that we have put forth. I believe the evidence that we will present this evening, which is directed really to the first part of this proceeding, will establish that there is an invalidity in this ordinance that needs to be corrected. And we appreciate your consideration and your presence here this evening. Thank you.
Thank you. Attorney Miles, you're free, wherever you're comfortable, to stay there, stand, go to the podium, whatever you like.
Thank you. My name is Donald Miles. I represent the 30 residents of Jessup Borough that were named by Solicitor Finucci, all of whom reside very near to the proposed site of this electric generation plant, and all of whom are aggrieved parties in accordance with the municipality's planning code, which is the state zoning law, and would suffer direct, immediate, and substantial damages if the requested zoning amendment is approved. It's important to note what this hearing is not about, because so much of what has been discussed in the community over the last few weeks is about things that this hearing is not about. Contrary to this flyer, it is not about $30 million in total tax revenues. It's not about 600 construction jobs. It's not about 30 permanent jobs. It's not about $500,000 per year given to community organizations. This hearing is about one thing and one thing only. Does the zoning ordinance of Jessup Borough exclude electric generation plants? As Attorney Wilson said, one of the zones in the borough, the M2 heavy industrial zone, permits electric generation plants. Their contention is that despite that, an electric generation plant cannot be built in that zone. The Jessup Borough Planning Commission recommended to Borough Council that the challenge to the zoning ordinance be rejected because it is not exclusionary. We will show with expert witness testimony that an electric generation plant can be built in the M2 zone. In fact, a variety of electric generation plants can be built in that zone, and this plant could be built in that zone. It's interesting that the three things that were cited by Invenergy, the 2,000-foot setback, the 70-foot height restriction, and the requirement that the entire project be contained in a single building, are all things that are customarily available to an applicant by variance. I practiced zoning law for 38 years, and I was a municipal solicitor. These are exactly the sorts of things that are granted to applicants when they request variances. But Invenergy has never requested a variance. Instead, they immediately brought a legal challenge to the zoning ordinance of the borough. Only if the ordinance as it exists is found to not permit the construction of electric generation plants does Borough Council get to the second stage to see what the remedy could be. And interestingly, the easiest remedy that could solve the problem, if there is a problem, was not one of the four that was proposed by Invenergy. If there are three restrictions that could not be obtained by variances, and of course we don't know that because they never sought the variances, in the M2 zone, those three restrictions could easily be modified. The 2,000-foot setback, which is rather large, could be reduced to 1,000 feet, 1,500 feet, 500 feet. The 70-foot height restriction could be extended higher. And the ordinance could be amended to allow a portion of the facility to be outside of a building. You'll hear expert testimony from the objectors that most of an electric generation plant, in fact, is inside the building. Only some of the equipment is outside. So, under the state zoning law and the case law, if there is an exclusion, your duty is to make the least change to the ordinance that satisfies the problem. Instead, Invenergy is asking you to ignore the legislative decision that you made when you decided you wanted electric generation plants in the M2 zone, the heavy industrial zone. They want you to cast that aside and do spot zoning in the M1A office park zone to allow their plant where they want to buy land. As I said, you never get to that issue if your ordinance is not exclusionary, and it is not. But even if it is exclusionary, the simple and least obtrusive way to resolve that is to make changes to the M2 zone that would deal with the three items that Invenergy has complained of. When it is our turn, we hope to demonstrate to you with expert testimony that the ordinance is not exclusionary, and that if you decide that it is, contrary to what your planning commission advised you, that what you should do is simply make three minor changes to the M2 zone and to comply with your legislative intent when you decided that a use such as this belongs in the heavy industrial M2 zone. Thank you.
Attorney Miles, you prepared to proceed with your case in chief? I keep doing that. I'm so sorry. Attorney Wilson. So sorry.
Yes, thank you. We brought along a binder of exhibits that we will utilize during the meeting. I'll start first by having a mark and handing them out to the council.
Folks, why he, Mark, this doesn't need to be, why he's doing that, the folks in the back, can you hear everything okay from all of the mics?
No.
They're saying yes way in the back. Who's saying no? Is it one particular mic that you might be having more difficulty with than another?
Attorney Wilson.
The podium not...
Attorney Wilson.
On the one on the table?
Move it closer to you.
To your mouth.
Craig, if you could remember to try to get as close all of us need to be reminded to get as close to the mic as you can. Each mic is a little different.
Things are going away.
Expect the council to read through that entire binder.
And this is calling speed face.
Open it and close it.
Speed readers. They have to be speed readers. Maybe it's somebody's wedding pictures. That's what might be in there. It's recipes.
He said, what if maybe there's someone taking photos?